We're going to talk ethics, and we got two real rock stars in our midst here. Christopher Lindquist is the principal appellate court attorney with the Appellate Division, 4th Department. And since 2010, he has worked in the clerk's office assisting the clerk of the court in providing support to the court in all aspects of attorney disciplinary process. Chris graduated from St. John's University School of Law, the same school of law which currently hosts the Robert H. Jackson biographer, John Barrett. I don't know if he had him or not, but maybe he'll talk about it. In addition, Winston Brownlow is the senior principal law clerk for the Honorable Patrick Niemoyer, who you just saw here, of the Appellate Division, 4th Department. Winston joined the 4th Department in 2012, where he served as the principal appellate court attorney and deputy chief appellate court attorney. He'll explain that. And before joining that, he was in the litigation associated with Paul Weiss, Rifkin, Wharton, and Garrison LLP in New York City. He's graduated from the State University of New York at Albany and was a summa cum laude valedictorian from the New York Law School, where he's the associate editor of the Law Review. Without any further ado, gentlemen, podium's yours.
Thank you. Thank you all for coming. My name's Chris Lindquist. As Greg said, I work in the clerk's office primarily on attorney disciplinary matters. I'm going to talk for about 25-30 minutes on the procedures for the attorney disciplinary matters. Then we'll turn over to Winston, who's got a topic to discuss, criticizing judges, I believe. The rule that prohibits lawyers from criticizing judges.
I'm not criticizing judges.
So, attorney discipline. As you can imagine, it applies to attorneys, and the discipline aspect is, obviously, the attorney is accused of some sort of wrongdoing. The primary question is, what types of rules apply to attorneys? What types of wrongdoing can become the subject of these proceedings? The rules are prescribed by the Appellate Division. Under New York law, the Appellate Division has exclusive jurisdiction over attorney disciplinary proceedings. The Appellate Division has crafted rules governing the procedures. The Appellate Division has also adopted and approved the rules of professional conduct, which can be viewed as the minimum standard of conduct that all attorneys must follow. Now, the primary purpose of the proceedings, and this is what the Court of Appeals has told us, is not to punish the attorney for wrongdoing, but to protect the public. And there's a few aspects of public protection that the Court of Appeals has identified. One is just simply to address unfit practitioners. Does a lawyer need to be removed from practice, their license suspended, or potentially the lawyer disbarred, because they can no longer be counted on to follow the rules? I mean, that's essentially part of the proceeding. The other aspect of the proceeding is to preserve the integrity of the bar. Lawyers have special powers under the law. They, under New York law, are the only people who are authorized to practice law, collect legal fees, give legal advice, appear in court on behalf of another. And with those special powers come special duties. So lawyers are cloaked with this presumption of integrity. And attorney disciplinary proceedings kick in when a lawyer has engaged in conduct that calls that into serious question. So the court, in addressing alleged misconduct, is addressing whether all lawyers will be somehow looked badly upon if this particular lawyer is allowed to continue in practice. And then the other aspect of the attorney disciplinary process is to educate and inform the bar and the public. And I'm going to go through the specific procedures later, but the driving point, the end result of all of these proceedings is public discipline warranted? And that's for the Appellate Division to determine. And if it is, the court does a written decision, imposes discipline upon an attorney, and we'll talk about the different forms of discipline that can be imposed. But that court decision and the consequences for the attorney who was found to have committed misconduct educates the public and the bar as to what is unacceptable. And I think if you look at the rules of professional conduct, we could probably do a week-long seminar on what those rules are and the obligations of attorneys to comply with the rules. But at the end of the day, there's a lot of reasonableness standards that are invoked in those rules. So is the lawyer doing something a lawyer is not supposed to do? And who answers that question? At the end of the day, the backstop is the appellate division judges. Now, we'll see during the process there is a grievance committee that can also make determinations of misconduct, but for public discipline, which is reserved for the most egregious cases of misconduct, that's for the appellate division to decide. So, one thing I want to mention, the disciplinary process is distinguishable from other manners in which an attorney can get into trouble or be disciplined. So you have trial court sanctions. Those can give rise to a disciplinary proceeding, but that is where the question is, has an individual attorney in an individual case engaged in conduct where they should be sanctioned, and a lot of times it's in the form of monetary sanctions. That differs from attorney discipline in the fact that the disciplinary process is more, does the public need to be protected from a particular attorney? It's usually not one instance of misconduct or one particular case or some sort of sanctionable conduct that's occurred at a trial court level. It's something bigger that invokes the disciplinary process. There's also malpractice actions. Those are individual clients are suing individual attorneys for a breach of some sort of duty to the client. Again, the disciplinary process is something bigger than just that individual relationship between one client and one attorney. There's also fee disputes. A common misconception is, well, if my attorney billed me improperly, I'm filing a complaint against them, I want them disciplined. Well, in New York, there's a mandatory fee arbitration for lawyers and clients who can't agree on a fee, and simply a disagreement about a fee is not necessarily misconduct by the attorney. It could be something simple as a misunderstanding as to what the agreement was. And the fee arbitration process specifically disclaims it does not cover any alleged misconduct by an attorney. So those are different than attorney discipline. Now, there's other regulatory issues that an attorney can encounter if they have a real estate broker's license, if they have a notary license. Those are all things that, if they get an adverse finding in those contexts, that could lead to an attorney disciplinary proceeding. But again, the disciplinary process is completely separate, and it's more of an overarching, does the public need to be protected from a particular attorney due to past misconduct? And one way to think about it is the disciplinary process relates back to the bar admission process. The appellate division not only disciplines attorneys, but it also is the only court with authority to admit attorneys to practice law. And for the lawyers in the room, you might recall that that was a lengthy process to get to the point where you were admitted to practice law school, the bar exam, the character and fitness process before the appellate division. All that years-long process was aimed at determining whether the lawyer as an individual is competent to practice law and has the character and fitness to practice law. The attorney disciplinary process is the reverse of that. Has this person who previously was thought to have those characteristics, had they done something that puts that in doubt? We'll talk about the players in the process, and I think the best analogy is a criminal proceeding. There's a prosecutor, and in the attorney disciplinary process, that's known as grievance counsel. And they are appointed by the appellate division, and they represent what's known as the Grievance Committee, which is probably best thought of as a grand jury. Grievance Committee is, at least in the appellate division, each district has its own committee, and it's 21 members, and I think there's 2 or 3 lay people. Other than the layperson members, they're all attorneys, and they convene probably 5 or 6 times a year. They review allegations of misconduct against attorneys and determine whether what's known as formal charges should be brought in the appellate division, which is the equivalent of an indictment. So the grand jury or grievance committee votes, and if a majority conclude that formal charges are warranted, then a petition alleging misconduct will be filed in the appellate division. The grievance committee can also take certain actions short of filing formal charges, and we'll talk a little bit about that when we talk about the grievance committee process. So back to the criminal court analogy, the trial court is the appellate division. The appellate division has original jurisdiction over attorney disciplinary matters. The appellate division is the trier of fact, and they determine whether the charges should be sustained, and if the charges are sustained, what sanction or sentence should be imposed. And again, we'll talk a little bit about the procedures in the appellate division later, how they arrive at that point where they decide whether the charges should be sustained and a sanction imposed. Now, there may or may not be a victim, or a quote-unquote victim, in the attorney disciplinary context. Generally, a client complains about a lawyer, or a judge complains about a lawyer, or opposing counsel complains about a lawyer's conduct, and that's how it comes to the attention of the grievance committee. But that's not always the case. The grievance committee reads the papers, they read court decisions. If an attorney is sanctioned for conduct in a court, the grievance committee might see that decision reported in the newspaper and look into it. If an attorney's convicted of a crime, that might make news too. There's no victim per se, but the grievance committee will take that up and determine whether the attorney has engaged in quote-unquote professional misconduct by virtue of the crime or the sanctionable conduct, and they will conduct an investigation. So one of the problems that comes up for people trying to tackle what this area is all about is cloaked in a bit of mystique, and it's because the process is confidential. Everything we just talked about, short of the appellate division issuing a public decision imposing discipline, everything that comes before that, which could be almost a year-long process, from the investigation phase of the grievance committee to the decision of the court, is confidential. The court does not issue public orders on interim decisions that may take place on motions in the proceeding or anything up until the final point where public discipline is imposed. So it's really difficult for practitioners to research how these play out. Now, there are court rules. As I said, they're relatively comprehensive. They do track the procedures from start to finish. But again, they're court rules, and they're worded in a way where the court has maximum discretion to procedurally steer the case in the manner that it sees fit and to decide the case ultimately. The other issue that practitioners confront is the legal authority is not necessarily consolidated. Again, I mentioned the rules of professional conduct. We could do a week-long seminar on those. A lot of the standards are worded in a way that it gives maximum discretion to the court to decide whether the rule's been violated. The judiciary law and other New York statutes also contain numerous provisions that govern expected conduct by, or mandated conduct by attorneys. And if those are violated, those can give rise to an attorney disciplinary proceeding. The other issue is, unlike a criminal case where once the charges are brought against an attorney, in a criminal matter, you have an idea what, if you're found guilty, what the sentencing range might be. In attorney disciplinary proceedings, the court has absolute discretion to determine the sanction or even just dismiss the charges, and it all depends. It's a very fact-intensive inquiry. So people find it a bit of a black box as to how to guide, if they have a client who's experiencing, who's been accused of misconduct, how to guide them through the decision-making process. Do they want to contest things? How far do they want to go? Do they want to admit certain things? Simply because the sanction is, I don't want to say a wild card, but it's very hard to determine ahead of that final moment where the court is determining the ultimate sanction. Then finally, another aspect of the process that gives rise to some uncertainty is, you'll see in the appellate division decisions that highly relevant to the final sanction is what the court terms aggravating and mitigating factors, which basically, if a rule's been found to be violated, that rule can be violated in 1,000 different ways. And depending on all the permutations of that form of the violation, the sanction can go from anywhere from dismissal or disbarment. For instance, misappropriation of client funds. All lawyers know that you have to preserve client funds, and you can't use them, for your personal use. But a highly fact-intensive inquiry gets invoked because it could be accidental. It could be the lawyer didn't know they were quote-unquote misappropriating client funds, or maybe they knew and used it for medicine for their sick child, which could be not so bad as gambling at the casino. So it's very circumstantial and fact-intensive how the rule is violated, and in the view of the court, how serious the conduct is, depending on those factors. And then finally, there's a very limited Court of Appeals review in this area. There's numerous, the appellate division issues disciplinary decisions all the time. You can read from any of the departments. They're on Westlaw, on their websites. The Court of Appeals takes up one of these cases maybe once or twice a year. And twice a year might be a lot. So there is a bit of the trial court say is the final say, and there's not a lot of analysis at the Court of Appeals level to provide some additional analysis on the legal issues that practitioners encounter during the disciplinary process. How are we doing on time? What time did I start, do you know? Okay, I don't know either. All right, I'll go for like 10 or 15 more minutes, and then we'll turn it over to Winston. So let's talk quickly about the Grievance Committee process, and that all starts when someone files a complaint against an attorney, or the committee sua sponte decides that it needs to inquire about the conduct of an attorney. And at that point, I think the Grievance Committee would refer to that as an inquiry. It hasn't blossomed into an investigation, but they've at least had something come to their attention that requires them to request documentation from the attorney or other parties and start to determine some of the facts that gave rise to the complaint. I think the Grievance Committee publishes statistics, and I'm pretty sure 9 out of 10 of these complaints end up not even developing into an investigation, simply because clients are complaining about things that the disciplinary process does not apply to, like I mentioned, fee disputes, something along those lines, or it's just something that does not rise to the level of what the committee would consider professional misconduct. My lawyer was nasty to me on the phone, or we just don't get along. He called me a name like that. It could, under certain circumstances, catch the Grievance Committee's attention, but I believe the statistics say 9 out of 10 of the complaints are closed without further action after cursory review by Grievance Committee lawyers. Once that initial fact-finding is done and the Grievance Committee determines that further investigation is required, the court rules provide for numerous tools for the committee staff to use to gather the facts. They can request documents, they can subpoena people, they can call in the attorney for an examination under oath. So by the time the investigation is done, which could take several months, the Grievance Committee has usually gotten relevant documents, taken testimony, gotten the subject attorney's written position about how they're explaining why what happened isn't misconduct. And then once that investigation is complete, committee counsel determines whether it will be presented to the committee with a recommendation. And the recommendation can range from what's called a letter of advisement, which is when counsel to the committee believes the lawyers come close to a line but hasn't crossed it, but it should be called to their attention that they've come close to breaching an ethical violation. The next level up would be a letter of admonition, which is a determination by the committee that the attorney has engaged in misconduct, but it's private, and it's issued by the committee, not the court. It never gets brought to the court's attention, but it is discipline under New York law. So confidential discipline by the committee. The next step up would be formal charges filed in the appellate division. Again, as I said, the committee votes on whether those are appropriate. And that, when the committee counsel recommends that, that is their statement that public discipline is warranted based on the facts as they know them. Because under New York law, the appellate division is the only entity that can impose public discipline on an attorney, and those sanctions range from censure to suspension to disbarment. Disbarment, we all know what that means. Your license is revoked and you're no longer an attorney. Suspension typically ranges anywhere from 6 months to 3 to 4 years. You generally don't see suspensions going longer than 3, maybe 4 years, because at that point the conduct is so severe that it warrants disbarment. And then censure is, the attorney does not lose the ability to practice law, but it's a public decision announcing that the lawyer has engaged in professional misconduct. So a couple practice notes. That one place where people get tripped up is attorneys have an ethical obligation to cooperate in the grievance investigation, and that's in the rules of professional conduct. And the attorneys that do not cooperate are subject to interim suspension, which is an application that can be made to the court by the Grievance Committee saying that this lawyer we suspect has engaged in serious misconduct, and, oh, by the way, they're obstructing or failing to cooperate in the disciplinary process, so they should be suspended while the charges are pending or the investigation is pending. So it's important for lawyers who participate in this process to realize that cooperating in the investigation is certainly in their interest. And that's something the court takes seriously when attorneys do not cooperate. Obviously, I think on a personal level, the judges assume the worst. Why aren't they responding? Well, they may have something to hide. Or if this is how they're representing themselves, how are they representing their clients? How can you represent a client if you can't take care of your own obligations during this process? All right, so let's talk about formal charges are filed, and then the procedures in the court once that happens. When the Grievance Committee files formal charges, it's in the form of a petition. It's now a civil special proceeding in the appellate division. The petition looks very much like a civil complaint. Count 1, misappropriation of client funds, all the facts that relate to that alleged violation, and then at the end of that count will be the alleged rule violations. And the petition I've seen them contain up to 13, 14 counts. Many times it's segmented by client matter, neglect of a client matter, misappropriation of client funds, and then failure to cooperate if that applies. So those are the types of charges that get filed in the petition. And under the court rules, the respondent's required to answer within 20 days. Now, once the answer is filed, that's really where the court starts to take an interest in, are there any issues of fact to be decided, raised by the pleadings, or not? If not, the matter will be scheduled for a final appearance before the court. And if there are issues of fact, then the court appoints a referee, which we have a list of referees. They're retired judges, and they take cases in their respective districts. And they then hold a hearing where there's a stenographer, there's documentary proof. They generally hold a hearing in a conference room at the Grievance Committee offices. The respondent's under oath. Both sides can call witnesses. And at the end of that process, the referee writes a report with findings of fact and conclusions of law. The appellate division is the trier of fact, though, so the referee's report is viewed as advisory in nature. I think we have cases that say credibility determinations by the referee are entitled to great weight. So once that report comes into the court from the referee, the matter is scheduled for a final appearance in front of the court, and that's unique to the Fourth Department. The other departments don't necessarily allow attorneys who are the subject of the charges to appear before the court. Most of the paperwork is the same with the pleadings, the referee's report. The parties' motions directed to the referee's report in all the departments. But one unique aspect of practice in the fourth is our court really does put a lot of weight on the personal appearance at the end of the process before the judges decide the case. They want to hear from the lawyers, but they particularly want to hear from the respondent, offer whatever explanation they might have. And you might have gathered from the presentation so far, by the time it gets to the court, the matter might have been pending before the Grievance Committee and the court a total of a year and a half. And as I said, the Grievance Committee has such broad discovery powers that usually all the documentary proof is in the pleadings, at the pleading stage, and is known. And lawyers, by the nature of the work, generate a lot of documents. So I don't want to say the facts are never in question, but usually by the time the charges are filed, there's not a serious question as to what happened. There might be questions as to who knew what and when, or whether someone's telling the truth or not, but the documentary proof usually tells a pretty complete story about what happened in the matter under review. Once the parties appear in front of the court and the respondent's given a chance to be heard in mitigation, the court, similar to what we just heard about appeals conferences immediately after the appearance, in some cases the matter's decided right then and there during that conference. In other matters, the court requests additional research or further review of the record, and notes get exchanged between the judges, and so it's not always decided that day, but some cases generate more discussion than others. So I got about 5 minutes left. I'm just going to, does anyone have questions on what I've presented so far? Right in back.
At what point does a lawyer who is the word respondent?
Yes.
Find out about the charge?
When a complaint is filed that the Grievance Committee is going to pursue, the lawyer is notified at that point, and I think the court rules specify, if the Grievance Committee doesn't outright dismiss a complaint within, I think it's 30 or 60 days, I forget, but there's a time window, they have to provide the lawyer with a copy of the complaint. That's not necessarily what the Grievance Committee will be charging, but that's at least what the client or the judge or whoever's filing the complaint has said against the lawyer. So the lawyer gets notice at that point that someone's filed a complaint, here's what it concerns. When it comes to charges, the lawyer respondent will find out before the committee votes what the proposed charges are, and the lawyer gets generally a chance to appear in front of the committee before the vote to be heard to explain their version of what happened. Does that make sense?
Yeah, so it's after that initial review, when the court or whatever, the committee or whatever the word is, to put it inelegantly, kicks out dumb charges.
Generally, yes.
Okay.
Yes. Any other questions? Okay. I have a few minutes. I have a list of frequently asked questions, so I'll just do my own questions here. One question that people ask is, does the court approve the charges before they're filed? Because I believe downstate that is the practice. The appellate division reviews the petitions before they come in and approves or disapproves the charges that are being, quote unquote, proposed by the grievance committees. Here in the fourth, that's not the case at all. The court has no knowledge of the committee proceedings or what the committee's voting on or what charges they're considering until the petition is filed, which, as we discussed, at that point it's already approved by the committee. So there's really, the court ultimately is going to determine whether the charges should be sustained. So in that sense, they're quote unquote approving the charges, but before they're filed, the court has no input at the committee level about what the charges should be in the case. Another question that I get is about an attorney's duty to report other lawyers for misconduct. Now, there is a rule of professional conduct that talks about a lawyer has an obligation, shall report another lawyer if they know that lawyer has violated a rule that raises a substantial question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer. So for the lawyer, I guess anyone can see, there's a lot of wiggle room in that rule. If you know they've engaged in conduct that raises a substantial question about their fitness as a lawyer, I mean, you could argue that both ways almost under any circumstance, but the rule is there, and that's what it says. Another question is, are lawyers ever obligated to report their clients for misconduct? Well, there is a rule of professional conduct that speaks to that as well, and it's couched in terms of defining what confidential information is and what lawyers are obligated to keep secret and not disclose. And that's essentially anything that's privileged and confidential or any other information that would be likely to embarrass or be detrimental to the client. Now, the exception to the requirement that that information be kept confidential is permissive. The lawyer may disclose information to prevent reasonably certain death or substantial bodily harm to another. So, and then anything necessary to prevent a crime or a fraud on another. So those are the two exceptions to the confidentiality rule that allow a lawyer to disclose information that they're otherwise required to keep confidential. So that's all I have for today, unless anyone has any further questions. Yes?
What if the questionable behavior is in a public forum, say published in a newspaper? Do we presume that the Grievance Committee reads the newspapers, or should somebody send a clipping in and say, look what this attorney just did or said?
From my experience, I presume the grievance committees read the newspapers because there's no shortage of sua sponte complaints. And just by virtue of the fact that you have 21 members of a committee who are all residing in that district where the attorneys who are subject to their jurisdiction practice, someone's going to hear about something if it's something along those lines. That's my experience. They I don't know if they go out and read court decisions or if they go on Westlaw and look for sanctions, because we see complaints where, a bankruptcy court has sanctioned an attorney, the grievance committee will pick it up and go with it. So I presume they read the newspapers, follow court decisions, and it's not just the grievance committee lawyers who are doing this. There's 21 members of the public who are also have their antenna up for things like this and can call it to their attention. Okay? Yes, right in front.
Is there a bar or level for prosecutorial misconduct? What is aggressive prosecution and what is going over the bar?
That's a good question. There's a rule in the rules of professional conduct that speak to special obligations of prosecutors. I'm not sure if it talks about overzealous prosecution or something along those lines. I think it's more geared towards the disclosure obligations that prosecutors have under Brady and similar cases. So I'm not sure of that. You may have read in the news that there is this prosecutorial conduct commission that's being formed or not formed, depending on court rulings that are supposedly going to take place later. So I'm not.
I suppose the court's going to say that case by case.
Yeah. Well, that's not to say that we've handled attorney disciplinary proceedings where the prosecutor is alleged to have committed misconduct. I don't know if it was under the rules for special prosecutors, or it may have been, misleading statements to a tribunal or something along those lines, which applies to all lawyers, but prosecutors aren't exempt from that.
Thank you.
So I don't think I really answered your question, but it's the best I can do. Okay. Anyone else? Yes?
Is there a statute of limitations?
There is no statute of limitations. And that's in the materials. I think there's a couple cases that it's definitely not in the rules or the law. And I think there's a couple cases, appellate division level, that say there is no statute of limitations. And my guess is it's by virtue of the fact that it's different from a lawsuit or enforcing private rights. It's for the protection of the public. That's probably the rationale. Okay? You're ready for Winston then. All right, thank you very much.
So I know Chris just talked briefly about a number of different rules of professional conduct. I'd like to drill down a little bit today into Rule 8.2a, which is been in the news a lot recently because it addresses criticism of judges and court rulings by practicing lawyers, often lawyers who get a decision and decide that it's maybe not exactly to their liking. I think Judge Curran actually referenced that. And the problem with this rule is that it's actually engendered a lot of debate and issues about its constitutionality, and it's really triggered a lot of issues about the First Amendment as applied to lawyers, and to what extent can lawyers opine on judges and court decisions in the exercise of their First Amendment rights. And it's really a fascinating topic. I mean, we have a basic premise, and I think, the Colorado Supreme Court said it very well in a case where a lawyer actually wrote a letter to a judge and said, and I'll quote, "I do not believe I can state my case any more emphatically. I want you off this case. I affirm my right to have my attorney's fees determined not by a judge who is racist." Yeah, merely sitting on this powder keg will not prevent it from exploding. And he went on and on about how this judge was racist and how he had demeaned him. Now, that letter was not published publicly, and that'll become important in just a second. But the Colorado Supreme Court, in discussing the constitutional implications of writing a letter like that and accusing a judge of being racist, started with this premise. We begin with the accepted legal principle that if an attorney's activities or speech is protected by the First Amendment, disciplinary rules governing the legal profession cannot punish the attorney's conduct. So that sort of sets the very broad stage for this rule. Yes, the First Amendment covers lawyers, and no, your speech cannot be sort of randomly and arbitrarily targeted for no reason for restrictions. Now, with that said, that is merely the basic rule. And courts have also recognized, however, and I'll quote this, that there nevertheless needs to be a recognition, and the Supreme Court has done this, especially in a case called Greer against the State Bar of Nevada, where they said that membership in a professional organization or a bar comes with certain obligations, and that one of those is to use temperate speech that does not adversely affect your ability to practice law, and that does not bring the tribunal in which you are appearing in front of into disrepute. And, we can all imagine the sort of generic policy reasons that we're interested in that, right? We want the public to be confident in the impartiality of the judiciary, and we want the public to feel like they can come to court and have their disputes resolved by honest judges, fair judges, impartial judges, because if they don't, they're going to go and resort to self-help. And that's not exactly the kind of society that we want to encourage, especially as attorneys. So, to sort of bridge this gap of the First Amendment on the one hand and an attorney's ethical obligations and professional obligations on the other, the courts have come up with a modified Sullivan test. Of course, we're all familiar with the basic standard for libeling a public official. It comes from the New York Times against Sullivan case from the Supreme Court in the 60s. In that case, the Supreme Court announced the actual malice standard, right? In order to libel a public official, you must act with actual malice, which means, knowledge that what you're saying is false and an intent to harm the other person. Most courts, I'll get that in a second, most courts have rejected that standard in this context. Most courts have adopted something called a modified objective test. The leading case is a case from the Ninth Circuit, Standing Committee on Discipline against Stephen Yagman. It was written by Judge Alex Kaczynski, who's recently had some of his own issues and is no longer serving on the Ninth Circuit, but I think we can all agree he's a brilliant fellow. And so the modified standard, he summarized the modified standard in the following terms. An objective malice standard strikes a constitutionally permissible balance between an attorney's right to criticize the judiciary and the public's interest in preserving confidence in the judicial system. Thus, the court must determine what a reasonable attorney, considered in light of all of his professional functions, or her, would do in the same or similar circumstances. Now that differs, of course, from the pure Sullivan test in that it requires what a reasonable person would do. The Sullivan standard merely asks whether you, as an individual, knew that your statements were false. Now, there's a couple of caveats to that. First, what you say must actually be false in order to subject you to discipline. And the Yagman opinion is very clear on this. It must be provably false, objectively false, not merely some people can believe one thing and some people can believe another. Statements of opinion are protected by the First Amendment, as are statements of, quote, rhetorical hyperbole. To that end, the Court of Appeals, our New York Court of Appeals, all the way back in 1973, had this to say. The lawyer actually wrote a letter in which he said that appellate judges were, quote, I'm not saying this, he is, appellate judges are whores who became madams. Now, I think that would probably attract the attention more than, but he said it and he published it, so there you go. The Court of Appeals actually reversed the First Department's imposition of sanctions against this attorney. They held, without more, isolated instances of disrespect for the law, judges, and courts, expressed even by vulgar and insulting words, or other incivility committed outside the precinct of the court, are not subject to professional discipline. Nor is the matter substantially altered if there is a hyperbole expressed in the impoverished vocabulary of the street. However, persistent or general courses of conduct, even if parading as criticism, which are degrading to the law, the bar, and the courts, and are irrelevant or grossly excessive, would present a different result. Now, I would leave it for you to decide if you understand what, a parade of criticism which is degrading to the law, the bar, and the courts, and is grossly excessive, and, what that means. But that is sort of what the Court of Appeals has said in that context. So, let me see how I'm doing. Okay, so let me get into the facts in Yagman, because they're actually, I dare you to find a case with more interesting facts or more twists and turns. If you do, please email it to me, because I would be fascinated to see it. This fellow Yagman was a practitioner out in Los Angeles, and let me get the case back here. He had this long-standing dispute with the chief judge of the federal district court in the Central District of California. He frequently moved for this judge's recusal. This judge then, which the Ninth Circuit even ordered one time. The Ninth Circuit actually ordered this one judge off one of his cases. This district judge then sued the Ninth Circuit directly in the Supreme Court. I'd never seen that before. I don't know if you have. But the Supreme Court actually issued an opinion upholding the Ninth Circuit's right to disqualify or to reassign this particular judge. So the long-standing history of animosity between this judge and this lawyer is maybe unparalleled. So here's what this lawyer said. This judge has a penchant for sanctioning Jewish lawyers, me and some others he named. I find this to be evidence of anti-Semitism. He also reported that this judge was drunk on the bench. And he later stated, this judge is the worst judge in the Central District. It would be fairer to say that he is ignorant, dishonest, ill-tempered, and a bully. He is probably one of the worst judges in the United States. If television cameras were ever permitted, the other federal judges in this country would be so embarrassed by this buffoon that they would run for cover. One might believe that some of the reason for this substandard human is the recent acrimonious divorce through which he recently went. but talking to attorneys who knew him years ago indicates that, if anything, he has mellowed. Outspoken, I guess. So the Lawyers Committee, sort of the equivalent of the Grievance Committee that Chris was talking about for the Central District in California, convened, charged him with a violation of Rule 8.2a, and charged him with making false and reckless statements about the integrity of a federal judge. And a 3-judge panel in the district court suspended him from practice. On appeal, the Ninth Circuit reversed. And there's been a lot of misunderstanding about this decision, actually. And they took all 3 statements that groups of statements that he made, and they sort of analyzed them against the baseline standards that we just discussed. It must be objectively false, not rhetorical hyperbole, and it must be something that a reasonable attorney in the circumstances would understand was false. And they said none of his statements met any of those conditions. Well, not any of them, but they went through them. They said the statements about evidence of anti-Semitism. They said, well, that's his pure opinion. He laid out the facts against which his opinion was based. This judge had sanctioned, him and several other Jewish attorneys. And then he drew a conclusion from that. That's an opinion. If you disagreed with that opinion, and the circuit court went out of its way to say, oh, and we do, then it's protected opinion statements. The second statement, that he was dishonest, ill-tempered, all those lists of, a subhuman person, all of those things, they said that was rhetorical hyperbole. Neither true nor false, something that any reasonable person would understand not to be an assertion of fact. Finally, was the drunk on the bench comment. They said, well, yes, that is, in fact, a false statement of fact, or a statement of fact. Sorry, it's a statement of fact. It is either true or it's false. He either was drunk or he wasn't. The problem was the Grievance Committee and the 3-judge panel hearing the case merely assumed that it was untrue, and they explicitly said that in their decision. Without any corroborating evidence, we would presume that a federal district judge appointed by the president would never show up in court, be on the bench drunk. The Ninth Circuit says, yes, of course, we agree with that as a matter of fact, but the committee did not prove that it was false. Maybe he was drunk. We can't say. And that's another key thing. The committee and the prosecutorial authorities, the Grievance Committee, always bears the burden of proof. So even if you make an outlandish statement, like the judge was drunk on the bench, they need to have some proof that he or she wasn't drunk on the bench. And we can't merely presume that judges would never show up on the bench drunk. So they dismissed that case. That decision has come under a lot of attacks. A lot of other courts have said it really gives lawyers too much of a pass. And the problem is, I think a lot of it doesn't take into account some of the unique procedural aspects of that case. So, for example, the Delaware Supreme Court has said that, that Yagman simply allows lawyers to make false statements. They didn't say that. They simply found that on that evidence, and because this was a proceeding that originated in federal court, they were the plenary, as Chris mentioned, they were the plenary triers of fact, that it wasn't false. A different case was presented, for example, in Idaho, in the Idaho versus Top case, where the lawyer made a much more restrained comment. He simply said, there's no difference between these two cases except one judge wasn't worried about the political ramifications of his ruling. Now, there, unlike in the Yagman case, in the Top case, they actually stipulated before the referee that the judge who he was accusing of having political considerations, would have come in and would have testified that he didn't have political considerations. Therefore, they said, objectively false. Okay. How are we doing?
I think we're getting close.
Getting close? Okay. Well, that's sort of just an interesting. One more idea. Some states, Texas, Oklahoma, and Tennessee, have adopted a pure New York Times standard, which shows that you must actually subjectively know that what you're saying is false, not merely that a reasonable lawyer would know that it's false. New York has adopted the objective test in the Holtzman case back in the 80s. Colorado kind of has this middle ground where they say it's the full New York Times standard applies if you communicate the issue privately, but that or they at least implied that the objective standard might apply if you communicated your, complaints broadly and disseminated it to the public. So, just a little primer on a sort of an interesting ethical issue that's very much in our public consciousness right now. Thank you.
Thank you.